Chief. Happy New Year to all of you.
Wait, please. My lord, it's an eviction matter, my lord. So, my lord, a notice of eviction has been given. 3 days time has been given. Notice dated 3/1/2025. So today is the date of eviction. So, my lord, my humble submission before your lordship, if possible, at 2, my lord. Otherwise, my lord.
All right. Yes.
Apply solution.
May I please, Lordship, I beg to mention for listing for motion, my lord.
Motion.
Motion, my lord.
When was it filed?
Today, my lord.
Today.
Today, my
It
lord.
will come. Why are you making a mention now?
Lordship, on Friday, my lord.
No, no. Subject to clearance of defects. It will come on its own. Don't make a mention. You're filing it today. They'll check up whether there are any defects.
So that's why, my lord, I pray on Friday, my lord.
No, no, no. It will come on Friday. If it doesn't come, you make a mention.
Maybe,
All right.
no stop.
Yes.
Therefore, listing a fresh motion matter, lordship, on Friday.
When did you file it?
Yesterday.
Then same thing. If it doesn't come, you make a mention.
My please, your lordship, I beg to mention for listing a matter for admission, lordship.
Admission.
Yes, lordship. On Friday, lordship.
No, not on Friday. On 21st January. 21st.
After Bihu.
Yes.
Me, please, Lordship, I beg to mention a fresh writ petition for listing, Lordship. We have filed it on 4th, Lordship. The matter is of urgent nature, Lordship, because
4th.
on 4th, Lordship.
4th is a Sunday. Would not have filed it.
Saturday.
3rd.
May I please, your lordship?
So it will come on its own.
Lordship, because the
What
matter
is the urgency?
Lordship, the respondents herein have resorted to extrajudicial methods to evict the parties from the official.
All right, Friday.
May I please, your lordship?
Friday.
Lordship, if possible, Lordship, day after tomorrow. Lordship,
Day after tomorrow, not possible.
Lordship, the parties will be evicted, Lordship.
No, day after tomorrow, not possible. You filed it. You should have mentioned on Monday if it is so urgent. Friday.
My lord, on admission matter, very urgent matter, my lord.
Why? What is the urgency?
Urgency, my lord, I want to sell my land, my lord, but the sale permission has been cancelled, my lord, without genuine ground, my lord. I have no encumbrance also, my lord, for selling this land, my lord. And my husband is suffering from heart disease, my lord.
Then 21st.
My lord, it would have been better during these days, my lord.
During these days, when do you want it? It's not possible.
Friday, my lord.
Friday we can give you. There are 43 matters already fixed.
And after the my lord.
21st.
21st.
May please, your lordship, I beg to mention item number 18. We have the consent from the other side. Conducting counsel, Mr. B. Pathak is in bereavement.
Item number
18.
18.
Yes.
Item 18, on the request made on behalf of Mr. B. Pathak, the matter stands referred to be listed again after 4 weeks. As it is submitted that Mr. Pathak is in bereavement. Yes.
May it please, Lordship. Lordship, I beg to mention to read petition for listing.
Listing, all right. 30th of July, 30th of January.
Lordship, it's the matter for admission.
30th, 30.
Yes. May I please, Lordship? Item number 19, Lordship. I have taken the consent from the other side. Kindly the matter will be taken up after Bihu vacation, Lordship.
January 27th.
Bless.
Apply. Item number 19.
For admission, item 1.
May it please, Lordship.
Yes.
My appeal was rejected by the appellate authority on the ground of limitation, my lord, ignoring the, my lord, benefit granted by the honorable apex court in suo motu extension, my lord. Similar letter which came up before a coordinate bench, my lord, and coordinate bench has allowed the appeal, my lord, allowed its placing the order, my lord.
You were required to file the appeal when?
Not, I was required to file appeal, my lord, if you take into account, my lord, the limitation granted by Supreme Court, my lord, it would ought to have been my 29/5.
The order in original was 28/1.
28/1, my lord.
So you are required to file appeal within,
With 90 days from 1st of March, my lord, if we get the, taken into account 90 days granted by honorable apex court, my lord.
so
My lord, appeal
90
was
days would expire on.
my 29/5/2022, my lord.
uh,
An appeal was filed on 17/5/2022.
And the apex court had extended the limitation to.
For 90 days, lordship will find, my lord, at page 70, my lord. I have annexed the order. In relevant paragraph, my lord, will find it page 73. Page 73, my lord. Second paragraph. May I read, my lord?
Yes.
In cases where limitation would have expired during the period between 15/3/2022 till 28/2/2022, notwithstanding actual balance period of limitation remaining, all persons shall have a limitation of 90 days from 1st March 2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, the longer period shall apply. My lord, from 1st of March, my lord, I have 90 days, my lord. Then I have preferred appeal on 17th May, my lord. It is within time, my lord. 90 days would expire on 29/5/2022, my lord.
Yes, what do you say?
Lordship, the Supreme Court has stated that the limitation period will expire. The period has been given from 15/3/20 to 28/2/2022. The limitation period. Here in this case, the order in original was passed on 28/1/2022. And the limitation would have expired on 6/4/2022. So it is not coming within the period which has been prescribed by the Supreme Court. And further, if 1 month more period has been granted, then it will come on 6/5/2022. But the appeal has been filed on 17/5/2022. It is beyond the period of limitation. Because
No,
it is- but
the para 3,
Lordship, 3A.
para 3 says where the limitation would have expired between 15/3. Here the limitation doesn't expire on 15/3. What I want to understand is your order in original is 28/1.
28/1/22.
My lord.
So your otherwise statutory limitation will expire when?
It will expire, my lord, on 7th April 2023, my lord. 2020.
How
2
many
months.
days? 90 days?
90 days.
Ah.
2 months plus 1 month, my lord.
2 months plus 1 month.
So 27th April.
My lord. If this 90 days is not taken into account, my lord, then lordship may also see page 72, my lord. First paragraph. Page 72, my lord. First paragraph of the order dated 23/3/2020 is restored in continuation of the subsequent order dated 8/3/2021, 27/4/2021, and 23/9/2021. It is directed that the period from 15/3/2022 till 28/2/2022 shall stand excluded for the purpose of limitation as may prescribe under any general or special law in respect of all judicial quasi-judicial proceeding. Meaning thereby, my lord, the period from 15/3/2020 till 28/2/2022 shall stand excluded, my lord. Therefore, my lord, I would be entitled for 90 days, my lord.
You are entitled to another 30 days. See,
My lord.
your original order was on 28/1,
My lord.
right? So
It was communicated on 6/2/2023, my 2022.
28/1,
28/1 is the order date, my lord. It was communicated on 6/2/2022, my lord.
6 to
2022, it was communicated, my lord.
2022. Then you add 90 days will be on
6364656 22.
6/5.
Lordship.
Now on 6/5,
My lord.
you filed it on
17.5.
17/5. Now in view of this para 1,
My lord. This,
you are getting 30 days more.
that means, my lord,
This period of 15/3/2020 to 28/2/2022 shall stand excluded.
Excluded.
So the order was passed on 28/1/22.
122.
So from 1st of February to 28/2, that has to be excluded.
Excluded.
So which means you get another 30 days,
my lord.
which is 6/6. Yes?
My lord.
All right. Third, consent your party is disposed.
Much obliged.
Items 2 to 13.
All these cases are regarding non-implementation of ROP 2017 by the board, my lord. Assumption Housing Board, my lord. These persons, all these persons have been working there and they got left. 2017 ROP had come into force from the 1/4/2016. But the board has taken a stand that they have not implemented it. In fact, my lord, in the service book of all the petitioners, my lord, that had been entered. That 2017 ROP will be implemented and this it will be given. But the board has taken now said that the ROP has not been implemented, my lord. In fact, there is no board should have by now taken the now in the month of January this month, my lord. 8 pay commission is coming up, my lord. This is a 7 pay commission until date, my lord. More than almost 9 years has crossed, my lord. They have not taken any stand regarding implementation of this.
What is their stand in the affidavit?
Stand in the affidavit, the board has not taken till now, though it has been entered in the service book of the petitioner that 2017 will be implemented, but board has not taken a stand that we implement it till then. And board should have taken a call till now, and that call has not been taken, my lord. Though they earlier ROP 2010, they were getting it the salary, and still till then that ROP 2010 has been they are getting the salary in 2010. In the meantime, my lord, in item number 13, he is the person who has retired my lord. And in the meantime, board has given the present and that particular person, my lord, item number 13, interim relief regarding ROP, my lord. And now they are continuing with it to the present petitioner without implementing the ROP 2017. They are giving it as an interim, my lord. Interim relief to all the person every month, near about 10,000 and odd rupees, my lord. Lordship, if Lordship takes up my additional affidavit, my lord,
In,
in the item number 1, my lord, Lordship will find, my lord, it is in additional affidavit, there is the page number, running page number 43, my lord. Original copy 43, my lord. So this is the budgetary allocation for the year 2025-26, my lord. Lordship will see, my lord, in the head, my lord, grant in aid as per ROP 2000. They take grant in the name of ROP 2010 new revised. However, they say that it has not been implemented. At the same time, my lord, in the right-hand side column, expenditure and liability, my lord, in the second column, it says the outstanding retirement dues after implementing ROP 2017, amount of 13 crores. But at the same time, in the affidavit, they say it has not been implemented. This is the signature of the accounts officer of the board, man. My only prayer is they should take a call and implement the ROP.
yes,
Lords. Lordship, we are the state level undertaking enterprise, Lordship. We have yet to be implemented ROP rule 2007. Lordship, my counter affidavit, which was filed by the board, Lordship, in running page number 31, Lordship, I have filed a counter affidavit, Lordship. Lordship, para 4, Lordship.
Hmm.
Para 4, Lordship. In the regard to the statement made in para 5 of the affidavit in July, the respondent authorities respectfully stated that it is a fault. More so, it is stated that the Assam Service ROP Rules 2007 has not yet been implemented in Assam State Housing Board. Further, it is stated that the interim relief, which my learned friend has submitted already, interim relief, which are provided towards the existing employee, are not considered as the benefit of ROP 2017, Lordship. Besides, it is a procedure of the Government of Assam only. Moreover, it is clearly stated the answering department that the Assam State Housing Board has fixed deposit an amount of ₹6 crores which has been kept in reserve for construction of the office building in board's own land. It is stated that the total outstanding liabilities after implementing the ROP 2017 will be 23 crores approximately. The fixed deposits are not enough to the cover of the entire liabilities.
no, you are reading from where?
Lordship, my counter affidavit,
Ah,
running page number 31, para 4, Lordship.
51.
Lordship. It is filed by the file on
Behalf of respondent 1, 2, and 3.
Lordship.
Yes,
File on 1st November 2025, Lordship.
Lordship will also produce paragraph 7 or 5 also. Subsequent.
No, there is one affidavit on behalf of respondent 1, 2, and 3 filed in July 23.
Lordship, after that, he has filed a
Reply.
affidavit in reply,
Hmm.
and thereafter I have filed a counter affidavit, Lordship. Court of such. Lordship got it, Lordship.
Yes.
Lordship,
Para 4.
para 4, Lordship.
Hmm. Why 2 counter affidavits?
No, there is an additional affidavit file. Thereafter, reply has been filed.
Hmm.
Lordship also produce the paragraph 5 also.
Lordship, paragraph 5, Lordship. Can I read, Lordship?
You are reading para 4.
Lordship, already I have read, Lordship.
Hmm.
Lordship, paragraph 5, Lordship.
Yes.
That in regard the statement made in paragraph 5, 6, and 7 are denied by the respondent, it is stated that the necessary entries were being made in the service book of the employee of the Assam State Housing Board for facilitating adopting of the Assam Service Rule 2017. However,
it is respectfully stated that same could not be adopted since Assam State Housing Board does not fulfill the condition laid by the Government of Assam notification so and so dated 17/1/2018, Lordship. It is, I have annexed that, Lordship, as per, as Annexer 1, Lordship.
What does it say?
Lordship.
Hmm.
This is the notification,
Hmm.
Government of Assam notification, Finance Department.
Which date? Date?
Date 17 January 2018, Lord.
Yes.
Lordship. In exercise of the power conferred by the proviso of the Article 309 of the Constitution of the Government of Assam, please to order the individual state level public enterprise may adopt the provision regarding revision of pay, scale allowances and payment of the arrear pay as prescribed to the Government of State Government employees as per the Assam Service ROP Rule 2017, published in the extraordinary issue in the Assam Gazette dated 17 March 2017 under notification so and so, subject to the following condition. This is just condition. Condition number 1, Lordship. The Board of Directors of each state level public enterprise shall decide to adopt the provision regarding revision of pay, scales, allowances, and payment of arrear pay as per Assam Service ROP Rule 2017. After examining the details, financial involvement regarding pay revision is to be allowed with the approval of the administrative department concerned only after the Board of Directors agree that state level public enterprise concerned has adequate financial resources to meet the expenditure for payment of the revised pay, revised allowances, or the arrear pay. Lordship, we the Assam State Housing Board we have the adequate financial condition. That's why we have yet to be adopted the ROP Rule 2017, Lordship.
No, but have you taken a decision on that?
Lordship,
Is there a decision that you don't want to take up ROP rules?
yet to be decided,
Then
Lordship.
you take a decision.
That's my question.
You
Yet to
take
be
a
decided.
decision.
And that decision, the finance department who has to be made the
Why?
party respondent in
No,
this
why?
matter, Lordship.
Why?
And our father
As
organization,
per this notification of 17 January,
Lordship.
there is a criteria. Whether you fall into that criteria or not, you have expressed in your affidavit.
Lordship.
But this is filed by whom? It's filed by
Commissioner.
Commissioner.
Lordship. Commissioner of Housing Board. Now, Housing Board probably there is a board which is
Yes.
constituted, isn't it?
Lordship.
Which will take policy decisions. So
Lordship.
whether you are agreeable to accept these ROP rules or not, whether you are competent to do it or not, is a decision to be taken by the board.
Lordship.
Has any decision been taken by the board as yet?
Yet to be decided.
Then-
Lordship. Yet to be decided.
Then how can the commissioner file an affidavit saying that you do not fit into this? There is no decision.
In that, in this regard, the yet to be decided the Board of Directors in Board of Directors meeting, Lordship. That is correct, Lordship. That is correct, Lordship.
Then
Another thing, Lordship, and the law is well settled that the salary would be included, Lordship. My counter affidavit in para 6, Lordship. The law is well settled that the salary would include the house rent allowances, the medical allowances, as well as the city compensatory allowances. Further, the question of the non-payment of the area salary as per the revised pay of the ROP Rule ROP 2017, the answering department to draw the attention of this honorable court to notification by so and so 17 March 2017. thereby notifying the Assam Service revision of pay rule 7/2017, wherein it has been categorically amended the rule 2B within bracket 4, that unless specifically extended under express order of the government, these rules shall not be applied to the officers and staff of public undertaking of the government of Assam. Lordship. In the ROP Assam Services Revision of Pay Rule 2017, that clearly stated that, Lordship, officers and staff of the public undertaking of the Assam government shall not be applied to ROP 2017, Lordship.
You come to the notification of 17 January.
Lordship.
Please read clause number 1.
The Board of Directors of the East SLPE shall decide to adopt the provision regarding revision of pay scale, allowances and payment of arrear pay as per Assam Service ROP Rule 2017 after examining the details financial involvement regarding pay revision. Pay revision is to be allowed with the approval of administrative department concerned. Only after the Board of Directors agree the SLPE concerned has adequate financial resources to meet the expenditure for payment of the revised allowances on the arrear pay. Lordship.
So it is ultimately the board of directors at the first instance who have to take a decision.
Has to be decided, Lordship.
Then,
Lordship.
so have you taken a decision as on date?
Yet to be decided, Lordship.
Okay. You take a decision
Lordship.
at an early date.
Lordship.
Place it before the board will decide it ultimately. They will put it in a fixed time, they should take a decision.
Take them. These writ petitioners, they're still employed or retired?
Yeah, they're all retired.
Retired.
All retired.
Small note, my lord, I have given in the last page, my lord, all the date of retirement are given.
Yeah.
That's all.
These the writ petitioners were earlier employed under the Assam State Housing Board. And upon attaining the age of superannuation, which is 60 years, the petitioners superannuated from the posts held, respective posts held under the Assam State Housing Board. So it is the case projected by the petitioners that during the subsistence of their services under the Assam services, under the Assam State Housing Board, the government of Assam notified the revision of pay within bracket ROP rules 2017 on 17th March 2017, showing stage-wise fixation of pay of its employees with effect from 1/4/2016. Stop. The respondent board it is the claim of the petitioners that the respondent board has adopted the ROP rules and necessary entries were made to the service roles of the writ petitioners maintained by the housing board. And thereby the petitioners were qualified to receive the pay scales as indicated under the Assam Services ROP Rules 2017. Stop. However, these revised pay scales were never received by the petitioners from the date of its effect till the date the petitioners superannuated from service. Stop. In spite of representations filed before the Housing Board, the dues payable to the petitioners have not been released. Stop. Therefore, being agreed, the petitioners have approached this court by filing the present writ petition. Better. The case presented by the petitioner is contested by the respondents by filing their affidavits and additional counter affidavits. Stop. Now here I got it the petitioner contention. The petitioners have also contended that the fact that the amount required to be paid after implementation of ROP rules 2017 to the various employees is also reflected in the accounts maintained by the Housing Board. The petitioners, by way of their affidavit in reply, have placed a copy of the budgeted year receipt and expenditure for financial year 2025-2026. Stop. From the said extract, the counsel for the petitioner submits that there is a provision already made within quotes, the provision already made for within quotes outstanding retirement dues after implementing ROP rules 2017 quotes closed. Stop. In respect of this provision, an amount of rupees 13.53 crores has also been reflected. Stop. The learned counsel for the petitioner therefore submits that the ROP rules have been accepted and adopted by the Housing Board, and provisions have also been made in their receipts and expenditure as reflected in the document, as reflected in the extracts of the receipts and expenditure for the financial year 2025-2026. And a provision, adequate provision has also been made towards release of these outstanding amount. Stop. It is therefore submitted that the claim of the petitioner towards the outstanding dues to the outstanding enhanced dues receivable after, in terms of the ROP 2017, be directed to be released to the petitioner by the respondent authorities. Without respondent or what have you. The respondents, on the other hand, duly contested the case by filing their affidavits. From the counter affidavit, it is pointed out by the counsel for the respondent that the board is yet to adopt the implementation of the ROP rules 2017 as in terms of OM dated 17th of January 2018. The Housing Board being a state level public enterprise, they are required to satisfy the norms prescribed by the notification dated 17th of January 2018 before the ROP rules 2017 can be accepted and adopted. Stop. It is submitted that the Housing Board does not satisfy the criteria specified in the notification dated 17th of January 2018, and therefore the claim of the petitioner is cannot be entertained, as the same is contrary to the notification dated 17 January 2018. Stop. It is submitted that since the petitioners do not satisfy, since the Housing Board does not satisfy the criteria specified under the notification dated 17 January 2018, the claim of the petitioner cannot be entertained, and ROP revised pay under the ROP 2017 cannot be released to the petitioner unless they are specifically sanctioned by the appropriate department in the government. Counsel for the parties have been heard. Pleadings available on record have been carefully perused. Stop. Although the amendments made in the affidavit filed by the Commissioner Housing Board reveal that the Assam Services ROP Rules 2017 has not been implemented in the Assam State Housing Board. And the amounts for ₹6 crore, which are kept in reserve for the construction of the office buildings on the board's own land, and the total outstanding liabilities after implementing ROP 2017 would be 23 crores approximately, and therefore the fixed deposits available with the board are not sufficient to cover the entire liabilities. Stop. However, during the course of the hearing, the learned Standing Council Housing Board fairly submitted that no specific decision has been taken by the board constituted under the statute for the Assam State Housing Board. No specific decision has been taken to either adopt or not to adopt the ROP rules. Stop. The learned Standing Council submits that in view of the financial condition of the board, it is not feasible to accept the contentions of the petitioners. Then a reference at this stage is necessary to be made to the relevant paragraphs of the notification dated 17 January 2017. Let me extract full number 49. Correct. The perusal of the notification dated 17 January 2018 reveals that This notification is in respect of state level public enterprises regarding adoption of provisions for revision of pay/pay scales, allowances, and payment of arrear pay as prescribed to the state government employees as per Assam Services within bracket ROP rules 2017. Stop. At clause 1, it is clearly provided that the board of directors of each of the SLPEs shall decide to adopt the provisions regarding the revision of pay/pay scales and allowances and payment of arrear as per Assam Services ROP rules 2017. Stop. Pay revision is to be allowed with the approval of the administrative department concerned only after the board of directors agree that the SLPE concerned has adequate financial resources to meet the expenditure for fulfillment of revised pay, revised allowances, and arrear pay. Stop. Therefore, it is clear from the said notification that the decision to adopt the provisions for grant of enhanced pay/pay scales or arrear pay in terms of the ROP rules 2017 is to be taken at the first instance by the board of directors of the SLPE, namely the board of directors of the Assam State Housing Board in the present proceedings. Stop. There is no dispute on fact that no such decision, either to adopt, not to adopt the ROP rules, have been undertaken by the board of directors. Stop. Although the affidavit filed on behalf of the Housing Board by the Commissioner Housing Board contains averments that the revision of pay rules and payment and release of enhanced pay scales to the petitioners are not feasible in view of the financial conditions of the Housing Board, however, there is no averment as to whether the board of directors had ever taken any decision in this regard. Stop. What is reserved for the board of directors of a state level public enterprise cannot be permitted to be undertaken by any subordinate authority unless specific powers have been delegated to such authority. So the board of directors is the prescribed authority in respect of the Housing Board to undertake any policy decision. Stop. Since no such policy decision has yet been taken by the board of directors of the Assam State Housing Board, this court is inclined to issue specific directions to the Assam State Housing Board to take all steps to place the matter regarding the consideration of the adoption of the revision of pay rules of 2017 and all other connected matters before the Board of Directors at the earliest. The Board of Directors will thereafter take a conscious decision in this matter after examining all particulars as is required under law, including the hardships faced by the erstwhile employees and the question of maintaining the parity of benefits between the employees of the housing board vis-a-vis the other state government employees. Stop. Let this exercise be completed within a period of 60 days.
Not.
60 days from the date of receipt of a certified copy of this order. Needless to say, any such decision that is taken by the board, the same shall be communicated to the writ petitioners. So, with the above direction, the writ petition stands disposed of. The writ petition stands allowed in part and disposed of. যাতে ডিটেইল বিলাক দিয়া আছে কোন কোন writ petition এতিয়া ৰিটায়াৰ হৈছে।
Please, Your Lordship. Lordship, we are being led by Dr. Saraf in this matter, Lordship. He is on legs before court number 1. She may kindly pass it over for timing, Lordship.
Some other day. Some other day.
For timing, he will come.
Maybe not some other day after tomorrow, madam.
Time being,
Lordship.
let us see.
Okay, straight.
Time being. Yes. Any affidavit filed?
Yes, the respondent has filed the affidavit, which copy they served today anyway. We are ready prepared for the case, my lord.
No, if they served it today,
No,
when did you file
we are
it?
prepared, my lord.
Huh?
We are prepared.
When did you file it?
Long back, my lord. Long back. During the vacations.
During the vacation itself, my lord.
Is it available here?
Oh, it's my lord problem.
23rd December.
Yes. Yes, my lord.
Okay. Yes.
Yes, to satisfy, my lord.
My lord, they have raised several disputes, my lord. Out of one, my lord, contract agreement, my lord. And to be precise, my lord, there are 7 disputes, my lord. The number first, and they have divided it as dispute 1, dispute 2, dispute 3, dispute 4, dispute 5, dispute 6. The main aim is, my lord, to overcome that condition that they cannot cross 20%. And they brought every, my lord, dispute within the, my lord, of within that percentage, my lord, of 20%, my lord.
Now, my lord, here, my lord, if your lordship kindly come to page number 349, my lord.
So all these can be examined by the
My
tribunal.
lord, no, it cannot be there, my lord.
Well?
My thing is this, my lord. The condition is very clear, my lord. Beyond 20%.
No. As on date, the law stands is very clear that the referral court's duty is only to see the existence.
Exactly, my lord. That is why, my lord,
Uh,
if it is a case, my lord, that they have filed, this is the first petition, my lord, that would have been their case, my lord. They have, my lord, if your lordship come, allow this, they will come with another 4, my lord, applications, my lord. And they will go on
Can
filing,
you
my lord.
prevent them to come? If they want to come,
My
they
lord,
come.
and what happened, my lord? They will, my lord, somehow, my lord, after going to arbitration, my lord, there is no use, my lord, of defending this, my lord. What I have felt, my lord, seen, my lord.
Why?
My lord, because, my lord, the provision of the contract is very clear, my lord. Once they cross to 20%, my lord, arbitration is exactly clause 7. I would like to, my lord, read the clause once again, my lord.
No, you are first referring to some page.
Yes, my lord. My lord, I'll go to the clause first, my lord. My lord, lordship may kindly come to page 120, 25, my lord.
Yes.
125. The provision of clause 63 and 64, 55.2, clause 55.2, to the general condition of content will be applicable only for settlement of claims of or disputes between the parties for value less than or equal to 20% of the value of the contract, and when the claim of disputes are of value more than 20% of the value of the contract, provision of 63 and 64 and other relevant clauses of the general condition of contract will not be applicable, and arbitration will not be a remedy. So, my lord, they have crossed. So, my lord, arbitration is not a remedy. Now, this arbitration agreement does not exist, my lord. They have exhausted, my lord, this remedy. So, there is no arbitration agreement. After, my lord, they have filed four arbitration petition, my lord. And, my lord, I will show, my lord, from the record, my lord, they have already.
In respect of the other arbitrations which are there,
my lord,
was it also court referred or
court
by the department?
Court referred.
So what orders were passed there?
My lord, it's here, my lord. My lord, do we have a next, my lord? My lord, first of all, what happened, my lord? First, my lord, dispute 2, 3, and 4 came before this honorable court. When, my lord, the core issue was pending before the honorable Supreme Court. Then this honorable court, my lord, I'll go to that judgment, my lord. The honorable court, by this court, my lord, has passed the judgment, my lord, at page 349, my lord. Starts at 349.
No.
My lord. Relevant portion is, my lord.
So this is awaiting the decision.
Yes, my lord. Then, my lord, they approach the honorable Supreme Court, my lord. Honorable Supreme Court, my lord, that judgment is 354, my lord. It says that no pendency of that matter, my lord, that the petitioner should not suffer, and they have appointed, my lord, arbitrators, my lord. So, my lord, this issue was not raised, my lord. Now, again, my lord, the fourth, my lord, was the dispute 4 judgment was they came with, my lord, another application, arbitration petition 25. Well, 854, sorry, my lord. My lord, it is at page Yes, my lord, 854, my lord. 854, my lord. Page number 854, my lord. It is, my lord, again, my lord. And lordship will see, my lord, from the relevant portion, it starts from 855. And it was again sent for, my lord, with the my lord, same arbitrators were engaged, my lord, and it was sent, my lord. Relevant portion is at 859, my lord. Now, my lord, when my lord fifth this my lord regarding my lord, now they have joined two claims, my lord, 6 and 7 together, because these two claims, my lord, individually does not cross the my lord that 20% bar. So from this, my lord, it is clear, my lord, only to my lord overcome that provision, my lord, they have my lord separated this claim into 7 claims. Fine, my lord, they have separated. Now, my lord, once they have, my lord, crossed this 20% bar, my lord, we have raised this, my lord, issue here in 6 and 7 that you have since that you have already preferred 4 arbitration petition, which, my lord, crosses this 20% bar. So now there is no arbitration agreement. You have exhausted this agreement. Arbitration is not a remedy. It is, my lord, clearly stated in this
in this 855,
my lord.
855 is a part of the same agreement.
My lord.
So this objection was not raised.
I was not there exactly, my lord. My lord, precisely, my lord, this kind of affidavit was not fine, and my lord, my lord, what I am submitting that once it will cross 20%, my lord, there is no arbitration agreement, my lord. That issue can, my lord, other, my lord, things, my lord, this honorable court cannot decide, my lord. Existence of arbitration, whether there is an existence of arbitration agreement, that can only be, my lord, decided by this honorable court. So, my lord, I am raising this point, my lord, by this 4 arbitration petition, my lord, they have exhausted this provision of arbitration. Now, arbitration is not remedy once it is crossed. And my lord, it is a conditional contract, my lord.
Yes.
My lord, through judgment, my lord, I have submitted, my lord. It is one is, my lord, 2018 6 SCC 534, my lord. I would like to read, my lord, para 7. 2018 6 SCC 534. And my lord, relying on para 7 in it, my lord.
Yes.
May I read, my lord? Para 7, my lord. To appreciate the rival submission, it is necessary to scan and scrutinize the arbitration clause, that is clause 13 of the policy. The said clause reads as follows: if any dispute or difference shall arise as to quantum to be paid under this policy, such difference shall independently of all question be referred to decision of a sole arbitrator to be appointed in writing by parties to, or if they cannot agree upon a single arbitrator within 30 days, of any party invoking arbitration. The same shall be referred to a panel of 3 arbitrators comprising of 2 arbitrators, one to be appointed by each of the parties to the dispute oblique difference, and the third arbitrator to be appointed by such arbitrators. And arbitration shall be conducted in accordance with the provision of Arbitration and Conciliation Act 1996. It is clearly agreed and understood that no difference or dispute shall be referable to arbitration, as herein before, provided if the company has disputed or not accepted the liability under or in respect of this policy. It is hereby expressly stipulated and declared that it shall be a condition precedent to any right of action or suit upon the policy that the award by such arbitrator of the amount of loss or damage shall be first obtained. When we carefully read the aforequoted clause 13, it is quite limpid that once the insurer dispute the liability under or in respect of the policy, there can be no reference to arbitration. It is contained in the second para of the clause. The third part of the clause stipulates that before any right of action or action or suit upon the policy is taken, recourse to prior award of arbitrators with regard to the amount of loss or damage is a condition precedent. The High Court and the High Court, as the impugned order would show, has laid emphasis on the second part, and on that basis opined that the second part and third part do not have harmony, and in fact sound a discordant note for this scheme cannot be split into 2 parts, once to be decided by the arbitrator and other by suit. Now, my lord, I'll come to para 23, my lord.
No, what do you want to show from this?
My
Para
lord,
7?
I'll first complete para 23, my lord. It does, para 23, my lord. Para 20.
Yes.
My lord, it is explaining, my lord. It does not need a special emphasis that an arbitration clause is required to be strictly construed. Any expression in clause must be unequivocally expressed the intent of arbitration. It can also lay postulates in which situation the arbitration clause cannot be given effect to. If a clause stipulates that under certain circumstances there cannot be no arbitration, and they are demonstrably clear, then the controversy pertaining to appointment of arbiter has to be
You did
put
not
to
do
rest.
an appeal after that.
My lord?
You did not file appeal in respect of the earlier or arbitrations which were appointed by the court.
My lord.
You accepted this.
My lord, we have not raised that point.
Not only accepted, my lord.
You did not raise is your problem.
My lord,
You
my lord,
can't be allowed to raise your objections in piecemeal.
My
That
lord,
in this
my lord,
particular litigation, you will raise a particular objection, and in a subsequent litigation, through hindsight, you realize, oh, some other defense should have been raised. That's not permissible.
my lord, if it have been a one.
If it is your argument
Hmm.
that these disputes cannot be referred to arbitration in piecemeal,
My lord.
in order to
Not piecemeal, my lord. I'm not saying about piecemeal, my lord. They can prefer any number of arbitration petitions. But once they cross 20%, no arbitration.
20% of what?
Of the contract value.
20% in each, or as
No,
as
my
a
lord,
total?
it's clearly stated, my lord.
Ah,
Not each, my lord.
ah.
It said disputes, my lord, clearly.
That's right. that's right.
Disputes. They have
Wait,
raised
wait.
several disputes, and my lord, by raising
So your-
earlier 4
your
disputes, they have
contention
crossed the
is
20%
that
limit.
Whatever disputes you may raise, the sum total must not be more than 20% of the contract. Is that what you're saying?
My lord, the claim amount
That's
of
right.
the disputes,
That's right.
not one dispute, my lord, of the dispute cannot cross 20% of the contract agreement.
Yes.
So, my lord, they have preferred earlier 4 arbitration petition, and thereby they have crossed 20%. So, arbitration
So all
is not a
these-
remedy.
All these
Now,
you should have raised before the, either you say that in the earlier proceedings where arbitrators were appointed by the court,
My lord.
they did not cross 20%.
My lord.
Now they are crossing 20%. Is that your case?
My lord, my case is that, my lord,
When did
argument sake, my lord,
When did they cross 20%?
partly yes, my lord, partly yes, my lord, because first 2 or 3, my lord, it has crossed, my lord. And secondly, my lord, for argument's sake, my lord, we accept that we failed to raise that issue, my lord. But that does not mean that we have to make that mistake again and again, whatever the petition comes, my lord.
No, you could have filed,
My lord,
you could have.
we have rectified our mistake now, my lord. This is a fresh petition, my lord. We have entitled to raise this ground, my lord. And my respectful submission is that, my lord, even if we have made a mistake in the.
If you are entitled to raise this ground, then you'll have to answer the subsequent question. Why have you continued to accept the orders passed earlier by the court?
My
What
lord,
steps have you taken to
I said,
rectify it?
my lord, I have submitted already, my lord. For argument's sake, my lord, we accept that we made a mistake, we could not raise, my lord. That does not mean that we have to commit the same mistake
Then you
again
have-
and again,
then
my
the
lord.
principle of
Negative
constructive
equality, my lord.
litigator will apply.
Yes, my lord.
Yes.
So, my lord, we are entitled to raise, my lord. We are raising, my lord. My
You are
lord,
not entitled to raise. That's
My-
what we are trying
my
to make.
lord, this is negative equality, my lord. We are barred because we have not raised that issue
You are
in
not
the earlier.
You have accepted the order.
Not accepted, my
You
lord.
have.
We have not
Because
accepted,
we
my
have
lord.
not filed any appeal.
My lord, we have not accepted, my lord.
Have you filed any appeal?
My lord, in
Against
34, my lord, we went to 34, my lord. All those arbitration petition has been challenged in 34, my lord. And my lord, that
34, you are challenging the award.
not award, my lord. That also awarded the challenge, my lord.
Huh?
But the 20%
Alright.
is also a challenge, my lord.
Whatever, the jurisdiction also you have challenged. I
It is
think-
not jurisdiction, my lord.
Well-
It is not jurisdiction, my lord. Jurisdiction, my lord, then my lord, it will be decided by the arbitrator, my lord. It is not about this. Why after crossing the 20% limit, where arbitration agreement exists, my lord. And as per the clause of agreement, my lord, it says that arbitration is not remedy once you cross 20%, my lord.
Right, we have heard you. You
My
are not
lord-
answering the queries of the court.
I will place the correct fact, my lord. Who is this? I don't know, my lord. This Pankaj Yadav, who had sworn the affidavit, Deputy Chief Engineer Construction, Pasighat, my lord. They have suppressed, they have served these copies. This must be bundle, but they have not annexed most important document because they went to Supreme Court and Supreme Court without issuing notice, I got dismissed. I'm placing this order. That is suppression of fact. Court should impose the cost on that.
My lord, suppression of material fact, my lord, I am in, my lord, dispute 5, my lord.
Why is so much of document submitted? Why he could not submit this document? Two-page document? Thank you. Against Honorable Justice Suman Sham order, they went to Supreme Court.
But my lord, this is
Then-
somewhat different, my lord.
Then
This
you
is-
said,
my
you
lord-
said there was no appeal filed.
That's
You're
why
telling
this
this
is
under-
all.
My lord, I was not there, my lord, so I am not aware, my lord.
Oh.
That is my submission, my lord.
Then
If
my lord,
not aware-
person should appear personally.
If you're not if you're not aware, then you should.
My lord,
make
if it is
statement.
filed, my lord, if it is filed, my lord, then my lord, the lordship query has been answered, my lord, by this order, my lord. Query has been answered.
This man should be bought like, who is this
My lord,
Pankaj Yadav?
but there is a basic difference, my lord. My lord, the question raised by
In
the
view of this order,
my lord.
in view of this order,
Hmm.
you're barred from raising this issue.
No, my lord. No, my lord, because my lord.
Have you gone through this order?
Yes, my lord, I have just.
Please read it. Please read it.
We are not inclined to interpret the impugn judgment. However, if claims filed are beyond the stipulated in clause 55 contract, it will be open to the petitioner to raise the contention of non-arbitrability before the arbitral
That's it.
clear.
That's it.
But it is not regarding not arbitrability, my
What
lord.
else?
It is different, my lord. That is what, my lord, from the day one I am saying. So I'm saying, my
What
lord,
is the difference?
lordship can very well, lordship cannot see anything else, my lord, as per the Honorable Supreme Court direction, my lord. Lordship can see only whether arbitration agreement exists, my lord. Now, my lord,
Right, we have-
beyond 20%, my lord, my lord, my specific submission is
We have
that
heard
there
you.
is no arbitration agreement once they cross, my lord, 20%.
We have heard you. We'll decide on whether to impose cost for wastage.
And that is only not there.
Fresh
Period
litigation
claim is
time.
that, my lord, claim number 2 to 5 already exceeded 20%. They have separate this. And most importantly, they thought that
My lord,
no notice has been issued to us, so we'll not know about the order.
my lord, they have said, my lord, only 20%. My specific submission is that once they cross 20%, there is no arbitration
We have heard
agreement,
you.
my lord. My lord.
For orders on 27.
And they could have submitted because they thought that we will not know about this order, my lord.
My lord, one more thing I want to bring before your lordship.
No, we have heard you. Hearing concluded.
wasted the judicial court time.
Item 16.
Price আছে মোটা থেকে দুই তারিখে দিব ন তারিখ এই তারিখে 5 তারিখে দিব
Yes, may please also. My lord,
Here we have filed
this
this counter.
This case relates to, my lord, the Lanka Municipal Board relating to, my lord, no confidence motion. Now, my lord, the no confidence motion was held and against the petitioner 1 and 2, that was lost, my lord. And subsequently, my lord, what happened? We came before this court, my lord, against the order of page 87, whereby additional affidavit page 87, whereby, my lord, it appears that despite the motion is lost, my lord, there was an attempt to dislodge, my lord, the board. And, my lord, our basic grievance was, once, my lord, the motion is lost, the official respondents, my lord, have no role to play at all. So therefore, tinkering with, my lord, the proceedings was absolutely unwarranted. And on that count, my lord, the interim order was passed. Page 87, if your lordship sees, this is an order passed by the secretary, my lord, addressed to the director, Municipal Administration, Assam. Your lordship has got it, my lord, 87. Additional affidavit, my lord. Because this order, we could, my lord, lay hand on subsequently, and thereafter it was, my lord, brought into record. With reference to the subject cited above and the letter quoted under reference, I am directed to request you kindly to intimate whether the body of the Lanka Municipal Board has been removed, and also to furnish the district commissioner report in this regard. Now, what had happened, out of total 13 members, my lord, 6 members voted in favor of the motion. And in terms of the, my lord, law, my lord, more than half of the members, my lord, are required to vote, my lord. And out
let us see the provision.
Yes, my lord.
Panchayat.
Yes, ma'am. Municipal board, my lord.
Municipal board.
Yes. এখন detail. এখন মানে amended version 28 পেরা additional affidavit. If your lordship sees, my lord, section 28 of the Municipal Act. Section 28, my lord.
My lord, the additional affidavit, they have said to have filed. Neither my junior received the copy, nor it was served on us. Let us verify the record, my lord.
Additional affidavit, my lord. We have not received the additional affidavit.
Copy is served, and on that basis, the interim order was passed, my lord. The interim order refers to the, my lord, order.
And caveator was heard.
And they were caveator, my lord. They were present, my lord, when the interim order was passed.
And now you are reading
No,
87.
caveator is okay, but
Yes.
whether the affidavit was filed.
Yes, yes, affidavit was served to them, my lord. And thereafter, the interim order was passed by this honorable court.
তুমি 87, 84 years old.
Side you.
8825 order, your lordship will see.
What is it?
এইটো প্ৰথম দিনাই দিয়া হৈছে, প্ৰথম দিনাই এইটো পিছত ফাইল কৰা নাই এইটো। এইটো ইনিশিয়েল পইণ্ট অফ টাইমত দিয়া হৈছে এইটো। তোমালোকৰ মিছপ্লেচ হৈছে বেলেগ কথা।
এইটো নেকি?
না পেজ 87 পেজ 87 সেপাৰেট স্যাৰ এইটো। এইটো এডিশনাল এফিডেভিট সেপাৰেটলি ফাইল কৰা হৈছে। যোনদিনা মোশনটো মুভ কৰিছো সেদিনাই
কপিটো দিয়া
হৈছে স্যাৰ।
আৰু কেবিনেটৰ অৰ্ডাৰ অফ মেনশ্যন আছে।
We have served copy, my lord.
No, I received from the government advocate.
But out of 13 members, admittedly 6 voted in favor of the motion. And as per requirement of law, it has to be more than, my lord, half of the members. So half, my lord, out of 13. 6 and a half.
Yes.
Half, my lord, of 13, 7.5 would constitute, my lord, the half. And therefore, my lord, rounding off would, my lord, lead to 8. So minimum 8 members.
First, take us to this provisions of the statute.
My lord, there is in fact, my lord, what has happened? We are seeking no relief against the private respondents.
You are the chairman.
Yes, 1 and 2, my lord, chairman, vice chairman. Our, my lord, main grievance is against the official respondents. And there is an order of this honorable court, if your lordship comes to order dated, my lord, 26/8.
Where is this? There has to be a notice.
My lord.
The notice was served on you for
Yes,
renewal.
yes, my
Where
lord.
is the notice?
In fact, yes.
In terms of court order.
My lord, subsequently, what has happened in terms of the court's order, this, my lord, meeting was held. Eventually,
No, the first meeting.
yes. My lord, if I take your lordships to, my lord, the order, the initial order passed by this honorable court, 8/8/25, the facts are recorded there. And on what basis, my lord, the interim order was passed, my lord, will also appear from there. So I take your lordships to, my lord, order dated 8/8/25.
Yes.
My lord, may I read it, my lord? So first para we may skip, my lord. I'll start from second para. This writ petition under Article 226 of the Constitution of India has been filed assailing the letter dated so and so, issued under the hand of the respondent 3, District Commissioner Hojai, Shankardev Nagar. Mr. Talukdar, learned counsel for the petitioners, while referring to the different annexures in the writ petition, has stated that the writ petitioners are the ward commissioners of the Lanka Municipal Board. Issues having been raised of proceeding in no confidence motion against the chairman and the vice chairman of the said board, the writ petitioner 1 and 2, the writ petitioners had earlier approached this court in WPC 3274/25, wherein by order dated 12/6/25, the special meeting sought to be convened for moving a no confidence motion against the writ petitioners was kept in abeyance. We are informed that the said writ petition was later withdrawn. Records reveal that another writ petition, being WPC 3580/25, was preferred by the writ petitioners when a fresh requisition was initiated by withdrawing the earlier requisition in which was in issue.
Just
one.
Yes.
Yes. When no interim protection was granted in the writ petitioners, they had approached an intra-court appeal, being writ appeal 219/24, which came to be disposed of on 14/7/25 on the following terms. Well, this is important. Accordingly, in view of the submissions made by the learned counsels appearing for the parties, more particularly the submissions made on behalf of the learned counsel for the appellants herein, this court, without entering into the merits of the matter, hereby directs the parties to hold the meeting for consideration of no confidence motion in terms of the requisition dated 13/6/25 on 18 July 25 at 11 a.m. in the office of the Lanka Municipal Board. It is provided that appellant 1 shall issue requisite communications to all the concerned for attending the meeting so scheduled on 18 July 25 at 11 a.m. in the premise of the Lanka Municipal Board, Hojai. It is also provided that the said meeting shall be so convened and held strictly in terms of the provisions of the Assam Municipal Act 1956 as amended with the above observations and directions. Writ appeal accordingly stands disposed of. Pursuant to the said directions passed in writ appeal, a no confidence motion against the petitioner 1 and 2 was held on 18/7/25.
Mr. Talukdar has drawn our attention to the letter dated 18/7/25 from the president of the said meeting written to the District Commissioner Hojai to emphasize that the resolution was supported only by 6 members, whereas the whole number of commissioners is 13, and as such the motion was lost, being supported by the less than half the commissioners. He has also drawn our attention to the impugned communication dated 21/7/25 to support the apprehension that the state authorities are making to move to replace the petitioner 1 and 2 as chairman and vice chairman respectively by an additional affidavit filed today. This is the additional, my lord. Attention has been drawn to the letter dated 4/8/25, wherein the Secretary to the Government of Assam, Department of Housing and Urban Affairs, Dispur, Guwahati, has inquired of the Director of the Municipal Administration as to whether the body of the Lanka Municipal Board has been removed and requested him to furnish a report in this regard. Mr. R.P. Sharma, learned senior counsel, appearing on caveat, has raised a preliminary objection that the petitioners in the writ petition have not challenged the resolution dated 18/7/25, and as a matter of fact, the said resolution has not been made a part of the records of the writ petition, stressing that in the absence of a challenge to the said resolution 18/7/25, the very writ petition would not be maintainable. He prays for dismissal of the writ petition. Mr. Sharma, learned senior counsel, has also referred to the decision of so-and-so, so-and-so. Para 8, my lord. Mr. Goswami, learned additional advocate general, Assam, has sought for some time to obtain instruction on the action being taken by the respondent authorities pursuant to the no confidence motion and also procure the records.
Okay, now we'll come back.
Well, or vice chairman may be removed from office by a resolution of the board in favor of more than half of the whole number of commissioners that shall have given their votes. In the present case, it is seen that the municipal board in issue has 13 ward commissioners, and the letter of the president of the meeting to decide the no confidence motion reflects that only 6 numbers has voted in favor of the no confidence. Para 13. Reference can be drawn to the judgment and order rendered in Jiten Saikia and another, reported in 2004 to GLT 233, to say that any fraction, even if it is less than 5, should be read as 1 when the no confidence motion are being considered. Here the number of commissioners being 13, half would be 6.5, which shall have to be taken as 7, and therefore the no confidence motion does not appear to have been supported by more than half of the whole number of commissioners. A prima facie case has been made out by the petitioners that more than half of the whole commissioners did not support the no confidence motion. The balance would tilt in favor of allowing the mandate expressed on the floor of the House to prevail over executive decision to act otherwise. Any interference in the functioning of the petitioners 1 and 2 in their respective post would not be in the interest of justice at this stage. Therefore, in my considered opinion, and more specifically in view of the letter dated 4/8/25, which is annexed to the additional affidavit filed by the petitioners, it is provided that till the returnable date, the respondent 1 and 2 and 3 shall not in any manner interfere with the functioning of the municipal board insofar as the position of the petitioners as chairman and vice chairman of the board are concerned. In other words, no steps to remove or replace them from the said offices shall be taken without the leave of the court till the next returnable date. So pursuant to the interim order, we are continuing. Now, my lord, my grievance is not against the private respondents. My grievance is against, my lord, the official respondents seeking to remove, my lord, the board. And therefore, my lord, the affidavit by the government, the respondents, my lord, would be necessary. Now, there is an order of this honorable court. If your lordship comes to order dated 26/8/25, my lord, the 3 weeks time was granted, my lord, to the government to file their affidavit to bring on record their stand, my lord. 26/8/25. Third, so-and-so of the petitioners, Mr. N. Goswami, learned State Council, prays for and is granted 3 weeks time to file affidavit in opposition. That stand, my lord, has not been brought on record.
In the writ petition, what is your challenge?
Our challenge is that the order of the secretary as well as the deputy commissioner, my lord, makes it clear that despite the motion is lost, my lord, there is an attempt to dislodge us, my lord. And these 2 letters, my lord, more particularly the letter of the secretary, where my lord.
Can it be construed to understand that this letter at 83, the letter of the district commissioner, appears to be seeking instructions from the director as to examine the documents and initiate any action deemed necessary.
Yes.
And the letter of the secretary
my lord.
is a follow-up. So far, no action has been taken.
May submit only.
No more query.
Whether any action is contemplated or not is a decision to be taken by them.
My lord, my respectful submission is, my lord, once the motion is lost,
They are not allowing.
No, you're right.
Yes.
Once the motion is lost, as per the rules, you are in place.
yeah,
But nevertheless, the government has initiated some clarity, some clarification.
yes.
Will it be prudent for a court to interfere with this communication? Because it doesn't reveal any conclusion contrary to the decision as on date.
No, my lord, if your lordship, my lord, sees 87,
Uh,
my lord, if we give a closer look, my lord,
uh,
it will appear that there is a move, my lord. Because your lordship will kindly see, my lord, what I have understood with all humility, my lord, what I'm trying to say.
No, you have to read 87 with 83.
83. Correct, my lord. If your lordship, my lord, I'm coming to 87 with reference to the subject cited above and the letter quoted under reference. I am directed to request you to kindly intimate whether the body of the Lanka Municipal Board has been removed
Hmm.
and also to furnish the district commissioner's report in this regard. Yes. Now, if my lord, my submission is, if there is no move to dislodge us, my lord, then my lord, that may be recorded. My lord, if my learned friend agrees to that proposition, that there is no move on the part of the official respondents to illegally remove us, my lord, then my lord, I get my relief, my lord.
Lordship, that letter of the Deputy Commissioner, Lordship, 21/7/2025, last election of the repression, Lordship. In this letter, I have the specific instructions. There is no move, Lordship. It's a routine manner, Lordship. It is for appraisal and record keeping, Lordship. The letter, Lordship. I have written instruction, Lordship.
My lord, that can may be brought on record, my lord, by an affidavit, 2 pages affidavit, my lord, that would
The
suffice.
Deputy Commissioner letter, Lordship.
The municipal board has been removed. Whether it has been removed, my lord, that query has been made.
Right.
And at that point of time, we were not, my lord, allowed to function. We were intimated verbally that you will be removed, my lord. So therefore, my lord, we rush to the honorable court, my lord.
All right. Yes, Mr. Sharma, what do you have to say?
My lord, the petition is in the first hand premature because we filed, my lord,
No,
Now-
who are you in the first instance?
we are responding 5 to 11.
You are the
What commission?
persons who had raised the no confidence.
Yes,
But it has failed.
no. I have, you also only come to my counter.
Uh,
Why this confusion created in the mind of the DC, whether it failed or succeeded, because the DC knows the ground reality of the district. Will also kindly come to the additional BDB, counter, they have not replied to it. Where at 8,
Hmm?
there are 8 onwards.
Hmm.
That Biswajit Dev, being the president of the special meeting dated 18/7/2025, he could not vote and therefore opposing the motion of the confidence. He was opposing it. There were 4 members out of 13 in their favor. On the other side, the members, including ex officio members who supported the motion of no confidence, namely President Respondent 6 to 11, and the MLA of Lumding LAC, which makes the 7, as would be evident from the proceeding of the meeting dated so and so. One thing you'll also can see in the Municipal Act, my lord, there is no, my lord, mode. How, in what mode the vote will take place? Either by raise of hand, by voice vote, or by ballot.
How was it done? Ballot.
No, nothing is there. It is totally silent. So it may be by raise of just voice. Yes,
But
I support
you were
it.
present, you know how it was done.
My lord?
They have not finished.
You, the private respondents 6 to 11 were present in the no confidence.
Yes.
So how was it done?
So, my lord, the MLA was invited by the Honorable Chief Minister to attend the meeting, and while going, he said, "I support the motion of confidence," and walked away. They have not recorded it because there is
How
no
is the MLA relevant here?
railway exception member under Section 11. He has the right to vote of the act. MLA, MP of the local area, they have got right to vote. So he supported our motion and walked away. But interestingly, the person who was chairing the meeting was in their support. So he did not mention his name.
only 6 members out of 13. Actually, there were 7 members who voted in our favor, in support of the motion. So, my lord, at this matter, either way, this way, another petition premature. And the DC was also confused, my lord, when he came to know internally that there are 7 members supporting the motion of no confidence and 4 against. So he referred the matter to the government. So my simple parameter, this petition can be disposed of, since they have not replied to my counter. It may be again remanded back for fresh meeting, my lord.
Well, you have to challenge it. You are not challenging
Which
it.
one?
The no confidence in his favor
Yes.
is not under challenge to say that it was done contrary to the provisions of the Act.
That I have said
You may have said, but this is his petition, not yours.
And my lord, now at best, my lord, it may go back for reconsideration, because and there should be, my lord, by ballot, not by the voice vote or raise of hands.
That we may consider in a petition filed by you.
Yes.
You have not filed it.
They have not also not replied to it.
Hmm?
They have not also not replied to our affidavit.
May not have, but it is not under challenge. That particular result of the no confidence has to be assailed by someone.
We
For us
have,
to
my lord,
look into
in this,
whether-
we have said clearly that there was the confidence motion was held blatantly in violation of the Act, my lord, provision of the Act, and there was no, since there was no secret ballot, and that's why the DC had to refer the matter to government.
What is your stand?
Our stand is that regarding the letter of the Deputy Commissioner Lordship, the last annexed which have been sent in the regulation, that is just information to the higher authority Lordship.
No, regarding the no confidence motion, is there any view of the government to say that it was correctly done, incorrectly done,
It is yet to
or
come.
there is some deficiency?
That is yet to come, my lord, because
Then?
they have challenged it and it got stay. That's why it is premature now. Let the government tell the
Are you
decision.
going to file it or no, or we close the matter?
We'll file.
Heard Mr. S.K. Talukdar, Clerk Council Petitioner, Mr.
And my lord, I think there is no extension of entry order. The Lord Simba kindly note.
Government Advocate appearing with the state, Mr. R.P. Sharma, Senior Counsel, assisted by Mr.
MH Srikiya.
M.H. Soikia appearing for respondent 6 to 11. The by order dated 8/8/2025, while issuing, this is while issuing notice.
Yes.
While issuing notice, this court had granted an interim prayer. That no steps to remove or replace the petitioners from the offices of chairman and vice chairman of which board?
Lanka Municipal Board.
Lanka Municipal Board shall be taken without leave of the court till the returnable date. Meanwhile, the pleadings are exchanged and it is the case of the petitioner that by the impugned communication dated 21/7/2025 and
4/8/25.
4/8/25, it is apparent that the government is contemplating to take steps to remove the petitioners, notwithstanding that the motion of no confidence against the petitioners had failed as the same was not supported by 6 whole commissioners.
7, madam.
No, by
More than half, madam.
by more than half.
Yes.
More than half of the whole number of commissioners in support of the no confidence motion. Stop. It is submitted at the bar that there are 13 commissioners
13, madam.
of the Lanka Municipal Board. And only 6 had supported in favor of the no confidence motion. Therefore, there ought to have been at least 7 whole commissioners, whole number of commissioners in support of the no confidence motion. Which would have consequently led to removal of the petitioner's stop. But that not having been done, and the no confidence motion having failed, the government is required to accept the outcome of the voting in the no confidence motion. And in terms of the provisions of the Act, the same having been failed, the petitioners ought to be allowed to carry on their, ought to be allowed to function till their full term, and no steps ought to be taken by the government to remove them in terms of the earlier no confidence motion, which had apparently failed to win the support of the majority members. So, better. Learned N. Goswami, Mr. N. Goswami, learned government advocate, submits that he would like to complete his instructions and file a detailed affidavit in this regard. He prays for 4 weeks time.
He's too long, man. Let him come.
3 weeks. 3 weeks time. So, Mr. R.P. Sharma on the other end has questioned the sanctity of the no confidence motion itself. He submits that no confidence, in the no confidence motion, the sitting MLA was present and had supported the motion, but subsequently had
Left the meeting hall. man.
left the meeting. So this was, however, not recorded by the officer presiding the same no confidence motion. Stop. If the vote or the support of the sitting MLA is recorded, then the no confidence motion would have is required to be accepted to have been passed, and a consequence thereof, the petitioners cannot continue in their offices. Stuff. Be that as it may, the government, state government will file a detailed affidavit explaining as to the proceedings of no confidence motion, explaining the procedure adopted and the conclusions arrived at in the no confidence motion, and the stand of the government to that effect. Let this affidavit, as prayed for, be filed within a period of 3 weeks. Matter therefore be posted again.
On 29 January.
3 weeks. 29 is not possible. We can have it on 3rd February. Be listed on 3rd February.
Yes, madam.
Interim orders passed earlier will continue.
Deeply obliged.
Obliged.
Supplementary list for admission, I think 20.
May I please, Your Lord? I'll matter may take up at 2, some difficulties there.
At 2.
Otherwise, Lordship, this matter has been, affidavit has been filed by the respondent, Lordship. Respondent number 3, which was directed by this honorable court to file explain under which provision of law the deputy commissioner has exercised to cancel the sale deed, Lordship, which is the only empowered the civil court.
All right, at 2.
Much of, highly pleased.
Daily date for hearing item 17.
KJ Lordship. My lord, petitioner is praying for disability pension because my lord, during my lord PT period, he fell down, my lord, and he was hospitalized, my lord. And finally, he was discharged on medical ground after entering 5 years of service, my lord. Annexure 1, page 13, my lord. Discharge certificate. And page 14, my lord. Cause of discharge, my lord, invalid pension, medical ground. Left hand side, my lord, page 14 of my writ petition.
You have come after, when were you discharged?
In the year, my lord, 1981.
Then? How have you explained the delay?
Delay, my lord, first of all, my lord, I have submitted various representation. They have not, my lord, replied to that, my lord. Finally, my lord, I have submitted a legal notice, my lord. They have replied to that, my lord. Reply, my lord, annexure 4, page 21.
You have to come up with some judgments
Judgment, my
in
lord.
support of delay. Why should we not dismiss it?
My lord, I have submitted many judgments, my lord. In my affidavit in reply, my lord, I have submitted one judgment, my lord. One bunch of judgment also I have submitted already.
Yes. Does it explain the delay part?
My lord, in my affidavit in reply, kindly see, my lord.
Yes.
Affidavit in reply, my lord, and this is the judgment passed by this honorable court, my lord. In similar situation, my lord.
Page number?
Relevant page, my lord, page 71. Para 17, my lord. May I read? Law is equally well settled that pension is not a bounty but is a right. Non-payment of pension, including disability pension, is a continuing wrong which gives rise to recurring continuing cause of action. In this regard, this court can gainfully place the reliance on the ratio laid down by the Honorable Apex Court in the case of M.R. Gupta versus Union of India and others reported in 1995, 5 SCC 628. K. Shankar Narayan versus Devakiyamma Malathiamma reported in 1996, 11 SCC, and Union of India and others versus Tarsem Singh and others reported in 2008, 8 SCC 648. In the case in hand, the claim of the petitioner for disability pension was rejected on 24/7/19 and the petition was filed on 28/7/2020. The employee has not taken any ground in rejecting the claim of the pension for delay. Rather, the claim was decided on merit on 24/7/2019. Therefore, in the considered opinion of this court, there is no unreasonable delay in approaching this court for grant of disability pension. Accordingly, the contention of the Union of India regarding the delay stands rejected. The judgment relied on by the respondent Union of India in given facts of the present case are not at all relevant and applicable.
In your case, when was it rejected?
In my case, my lord, 2024. Kindly see, my lord, their affidavit in opposition. In fact, my lord, they have not rejected. Kindly see their affidavit in opposition. First, my lord, come to page 42. Their annexure, affidavit in opposition.
Yes.
Page 42, my lord, annexure 2. May I read? My lord, may I read? Page 42, my lord. Ram Balak Roy, since the 19 September 1980, while on duty, the disease is attributable to and aggravated by active field service of Strenisius danesa. Then, my lord, the patient has a frequent attack on fits on slight ecstasy and mental stress and strains. Then, my lord, kindly see, as per records available and the present history of the case attributable and aggravated by active and strenuous physical and mental condition. They have, my lord, admitted that my disease is because of this stress and strain.
When was this given?
My lord,
What is the date of this report?
this report, my lord. This report, my lord. It's not clear, my lord. Then, my lord, kindly see next page. This is, my lord, page 52, my lord, kindly see 31 May 2024. They are annexed.
50?
52. They are annexed. 31 May 2024. Next 8, I think. Number so-and-so was enrolled in Assam Rifle on 1977 and discharged from service on medical ground on 14 December 1981 after rendering 4 years 11 months of qualifying service due to his disablement, idiopathic epilepsy. According to individual was boarded out from service under medical category EEEP with 70% disability and attributable to and aggravated by Assam Rifle service. However, pensionary benefit to this effect was not extended to the individual at the time of discharge. The case has now come to the light of the organization and found to be admissible for grant of disability pension. Hence, his disability pension claim under category B with 70% disability is forwarded herewith along with the following documents. These are the documents. They have, my lord, never taken that point that I have come delay. Lord, on merit they have said, my lord. Then again, my lord, page, my lord, 54, they are annexed. Page 54, affidavit in opposition. May I read, my lord? Para 3, WPC number 7, so this case, my lord. As per category B of Schedule 2 of CCS COP Rule 1939 provides that death or disability due to causes which are accepted as attributable to aggravated by government service, diseases contracted because of continued exposure to a hostile work environment subjected to extreme weather condition or occupational hazards resulting in death or disability would be example. Para 3 of the Schedule 2 of CCS COP Rule 1939 further provides that normal pension at the rate of 50% of the emoluments or average emoluments received during the last 10 months, whichever is beneficial to the government servants, and gratuity admissible under CCS Pension Rule 1972 plus disability pension equal 30% of basic pay, 100% disability. There shall be no condition for minimum qualifying service having been actually rendered for earning pension. They admitted that no length of service is required if otherwise due. No service gratuity shall be admissible for lower percentage of disability. The monthly disability pension shall be proportionately lower subject to the provisions of Rule 8 and subject to minimum of rupees 7,000. Then, my lord, page 55 of their affidavit, my lord. Page 55 of the affidavit in opposition, Annex 11. This is 25th June 2024. In reference to the subject mentioned above, I am to state that this office is not authorized to make any comment on admissibility grant of disability pension to the individual. On the scrutiny of the case, it has been observed that the medical board had already decided after careful examination that government service is not eligible for disability as per CCS COP rule as the disease idiopathic epilepsy is not mentioned in the schedule. They have said that my disease idiopathic epilepsy is not in the schedule. That is their only, my lord, ground. Nowhere, my lord, in
Where is the schedule?
in their affidavit, they have, my lord, in the book, it is there in the schedule. But my contention is that, my lord, I have replied to that, my lord, in my affidavit in reply. And my lord, one thing more, in my affidavit in reply, this.
TCS extraordinary pension.
My lord, in my affidavit in reply, this judgment I have annexed. Here also, my lord, this person is having non-organic psychosis disease, name of disease.
You show us
My
your
lord,
case.
my lord,
Where?
my lord. This is your rules, my lord. This is, my lord, I am relying on head note B. Disease affected by stress and strain,
Head note B, page number?
42. Because, my lord, they are saying that my disease is not in the schedule, my lord, but in the head note B, disease affected by stress and strain. So my disease will come here because in their affidavit, my lord, they have clearly stated that because of stress and strain, I am suffering that disease, first of all. And second is 42, my lord, head note B.
42 is something else.
They have admitted, my lord, my disease is because of stress and strain. I have now shown, my lord, that's why I am relying on this head note, my lord.
What is your condition?
Idiopathic epilepsy name, and this is a mental disease, my lord, just like epilepsy. So the head note, my lord, disease affected by stress and strain. So my disease will come under this, my lord, first of all.
Not, what is the name of that? What is is the disease mentioned here?
No, directly idiopathic epilepsy. This is a mental disease, my lord. But my lord, psychosis and psychoneurosis, these are also mental disease, my lord.
Maybe, but the condition is not mentioned here.
Directly not mentioned, my lord, but it will come under head note this disease.
How?
Because they have stated in their affidavit that this is affected by stress and strain.
No, stress and strain,
Yes.
right? But all
Here
stress
also.
and strain will not be here unless included.
And
It
my lord,
it will require interpretation.
my lord, as per Honorable Supreme Court, my lord, this judgment, my lord, my name is, my lord, it is included.
Where is that judgment?
And my lord, one more judgment, my lord.
Where is the judgment where you say the name is included? Which one?
Yes, my lord, this judgment, my lord, civil appeal number 2904 of 2011.
Is it in the bunch of
Yes, my lord.
judgments you have given?
Yes, my lord.
2904.
2011, my lord. Page number 6. Serially, my lord, 6, number 6. CA number 14478 2011, Ojit Singh. Idiopathic epilepsy.
It is not here in this bunch.
My lord, as per Supreme Court, if at the time of entry, no disease is recorded, it means that it has come after service.
Quite right, but it is, your case now boils down to whether the psychosis and psychoneurosis will also include the condition that you're suffering. That is
Yes.
your case.
Yes, my lord.
Mm. What is it that you want to point out?
Here, my lord, this disease, my lord,
Hmm.
idiopathic epilepsy, kindly see, my lord. All this petition, all are allowed, my lord. So my disease name is also included here, my lord. Idiopathic epilepsy. And they are saying again and again, I am aggravated attributable, and I will get, my lord. One more judgment, my lord, last. In the Barnes, my lord, same, my lord. That disease is also not included. So CGC has raised that objection, and this honorable court, my lord,
Yes. Mr. Chakraborty.
Lordship, admittedly, the disease is not included into the schedule, Lordship. There is one more aspect, Lordship.
Have you gone through these SLP judgment?
No, Lordship.
You have not shared the judgments. Have you not given your list of judgments?
SLP too.
Hmm? You go through the judgments.
In any case, Lordship, Rule 6(1) said no case to be reopened after from 5 years from the date of the injury.
That's not the ground of rejection.
That is not the ground of rejection, but rejection was the disease is not included.
It's, the
This
ground of rejection is
epilepsy,
not there.
whether this epilepsy come within the definition that
That's what the judgment says. Therefore, I want you to read it.
that psychosis and psychoneurosis, whether this will come within that,
That what you have to. That is what the judgment says.
it will come, Lordship.
You read it and tell us that it doesn't include. This will be Civil Appeal 2904 of 2011, along with other matters.
Pending to put this up.
Judgment and order dated 13 February 2015.
Because one of the judgment I'm relying wherein Supreme Court said that epilepsy is a disease which cannot be detected at the time of enrollment because there is only superficial examination unless one discloses, Lordship. That has been stated.
No, you read the judgment and tell us. And along with the medical records. We'll take it up again.
Lordship.
On 20 January 20. Referred hearing.
Can it be in 22nd, Lordship?
All right, 22nd.
Last item was in.
I'm sorry, my lord.
Yes,
I was in court one, I couldn't.
where is your counterpart? We were informed that there is some meeting or something scheduled to be taken. We can continue, but subject to there being no objection. Government advocate. You may begin.
My lord. But the issue is very short, my lord. A Northeastern, my lord, industrial development, the scheme was announced, which you'll also find at page 39.
39.
In the English version at page 46. It also see clause 4.2.
Yes.
All eligible industry units will be entitled to benefits under one or more comprehensive of this present scheme, even if such units are getting benefits under other schemes of the Government of India. So the benefits under this scheme, which has been announced, that capital investment scheme below, shall be granted irrespective of the fact that the unit is getting benefits
under any other scheme of the government of India. That is the, now the eligibility criteria, you'll also find at page 46A1. 46A1 को दस page
page number 8.
Huh? 8 को दस हाँ A1 को दस I'll take it or look. The scheme at page 48. The central investment and incentive for access to the credit. All eligible units in the manufacturing or service sector where in the northeastern region will be provided central investment scheme for access to credit at the rate of 30% of the investment in plant and machinery with an upper limit of rupees 5 crores. So under this scheme, 30% of the total investment made was to be granted subject to the maximum of rupees 5 crores under the central investment scheme.
Yes.
But thereafter, my lord, the petitioner made a total investment of rupees 30 crores, which you'll also find at page 20 of the writ petition.
Page?
Page 20, my lord.
Yes.
Now, there was another scheme of the government of India, my lord, which was named as a scheme for creation, expansion of food processing and preservation capacity of the Pradhan Mantri Kisan Sampada Yojana, under which the petition received rupees 5 crores, and the details are at page 440.
No, you refer to page 20.
20 is the investment, my lord.
Investment for which scheme?
Under the CIS, my total investment made in the
Present scheme.
in the scheme, in CIS scheme, my lord.
Yes.
Thereafter, you also will find at page 53. Which you'll also find at 175. On the right hand side, you'll also see page 175. Where another central government department is also providing subsidy to any industry need. The amount of subsidy under the scheme of ND so-and-so would be limited to an amount which is equal basis by central investment subsidy of 2 crore something had been denied.
No.
Now, the sole grounds and simple grounds that, my lord, the policy itself clearly provides that the central investment subsidy shall be provided irrespective of the fact that the unit is receiving the subsidy or granting aid in any other scheme. Now, once the industrial policy clearly provides for it, the state level committee has no power to
Reject it.
go beyond that and say that no, since the industry has received the granting aid in a some other scheme,
Hmm.
and thereby the amounts will be limited to the amount of eligibility subject to the amount which has already been received. Since 5 crores was received, thereby the 3 crores 36 lakhs has been denied.
We will come back again.
By
Is that no item 20?
Can it be taken up either tomorrow or day after tomorrow, my lord?
Tomorrow, day after, tomorrow.
Subject to convenience of your lordship. my lord.
We can take it on 20 if not convenient,
Yes.
inconvenient.
No problem.
20 January,
20.
it's a Tuesday,
20.
okay?
Is it a problem?
Kiran?
22.
Two, my lord.
2, there are many matters fixed.
21 then.
What is wrong with 20?
20. All right, my lord. 20, my lord.
Let us keep it on
Yes,
20.
yes, yes,
Otherwise,
yes.
we'll see. what-
Yes, 20, my lord. 20.
Because there are few matters on 20.
Yes, no problem.
As agreed to by the council for the parties, matter we listed on 2001.
Obliged.
This is for admission.
Yes, your
Fine.
Unlisted item WBC 93 of 2026.
Yes.
Wait, please, Your Worship. My lord, it is regarding acquisition of land, my lord. Now, what happened, my lord, earlier occasion, my lord, they issued us notice. On the basis of that notice, my lord, we filed some representation. Those representations were not disposed of. Accordingly, my lord, we approached before your lordship, and your lordship was pleased to pass order in those writ petitions, my lord. I am referring to page 26 onwards, my lord. So, my lord, your lordship will be pleased to see the operative portion at page 34, my lord. Para 4. Para 8, my lord. Shall I read, my lord?
Yes.
My lord. The petitioner's notices have not yet been disposed of by the respondent number 2. Then the respondent number 2 shall take those representations on board, which are annexed as annexure number A1 to A33 of the writ petition for consideration, and after giving due consideration shall dispose of the same by taking into account the grounds raised in the written objection by way of separate speaking orders. The respondent too shall pass speaking orders as expeditiously as possible, and speaking order so passed shall be communicated to the petitioners forthwith thereafter. To balance equities, it is provided that till such disposal is done by the speaking orders, no coercive action shall be taken against the petitioner in terms of notices and orders dated nil. It is further clarified that this direction only would be operative if in the meantime the representation have yet not been disposed of. So, my lord, now your lordship will turn to impugn notices, my lord, page 36 to 63. So, my lord, here it is said these sections of this Land Requisition Act is mentioned and notices were given. Now your lordship will turn to page 37. it is said, now therefore you are directed to vacate the said land forthwith and remove your belonging from the premises within 3 days. 3 days time given, man. From the date of issue of this notice, that is 3/1. Failing which eviction proceeding will be initiated against you without further notice, and such eviction shall be carried out at your risk and cost as per law. Now, my lord, my humble submission before your lordship. Your lordship is specifically directed that our representation may be taken on board and separate order may be passed on each representation and copy may be supplied to us. Nothing has been done, my lord. Now this eviction notice has been given. Not even in the eviction notice, it is not mentioned that High Court order is carried out. And thereafter this notice is issued. My lord. So my humble submission, my lord, it is very unfortunate, my lord, and very arbitrary. High Court directed that you take the notice on board, give decision, copy may be supplied to them separately. Now they are doing this, my lord.
Yes.
Only 3 days time has been given. We have our dwelling houses there.
Yes.
Since this matter is, my lord, moved as an unlisted production list matter, I have taken instructions from the District Commissioner Dhubri. I have received just now written communications in WhatsApp, my lord. Now it says, my lord, that speaking orders in here, my lordship, there are altogether 28 writ petitioners. And so far as the part and parcel of land that they are in occupation has been, my lord, spelled out in the schedules, various schedules appended to the writ petition, my lord. Those schedules, my lord, lordship will find, my lord, from page 14 onwards, my lord. From 14, my lord, to page 18. Schedule Z, that is 26, then A1, A2, 27, 28. Now, my instruction says, my lord, pursuant to order passed by this honorable court, which lordship has just now seen, my lord. Speaking orders were issued, my lord, and those were given to them. The petitioners have been given a right of hearing. They were heard, and thereafter speaking orders were passed. Number 1. Number 2, after passing of the speaking orders, this notice, my lord, dated 3/1/26 have been issued. And today, the eviction process, it started, my lord, at 7:30 today, and it is already completed by 1:40. So they are already evicted by now.
No, your eviction notice says is issued on 3/1.
3/1?
Giving them 3 days time.
Yes, 3 days time.
3/1, 3 days will expire today.
No, yes, one of the third, fourth, and fifth, my lord, it is third, fourth, and fifth.
No, date of issuance of notice, you have to
Yes.
give them within 3 days from the date of issuance of the notice.
That is true, but my lord, even under the scheme of the act, because these are lands, my lord, which have been acquired by the state.
No, whatever.
No, even my lord, my
We are not questioning your purpose.
Yes.
We are only asking you that you have issued 3 days notice.
Yes.
So 3 days notice will expire when?
3 days notices expired today, my lord, because these notices were today.
So, but then you have already carried out eviction.
Yes, eviction is carried out, so nothing survives in the writ petition.
How?
Eviction
You
by
have given
removing.
them, you have given them 3 days time,
Yes,
and before expiry of 3 days, you have evicted them.
but 3 days time, my lord, these are notices that is 3rd of January. So we take 3rd as 1 day, my lord. 3rd, 4th, 5th, today is 5th. So till 5th, if they do not vacate voluntarily, then they will be forcefully evicted. And this is what, my lord, section 4 of the Acquisition Act says, my lord. Even under section 4, no prior notice is necessary. Nonetheless, we have issued notice, given them time.
There is a division bench judgment, I think, where it says notices are to be issued.
No, notices are to be issued, my lord, in person of speaking orders. So therefore, if now that since speaking orders have been issued against each of the writ petitioners, this is what my written instruction says. And I will definitely file my affidavit. Plus, it will grant me some time to file my affidavit. I will file my affidavit because these are question of fact. Now, so far as my lord, interim protection is concerned, they are seeking an interim protection also. That interim protection is not maintainable, tenable in view of clear written instruction which I have received, my lord.
Is the eviction carried out?
Yes, today.
My lord, that I do not know, my lord.
Yeah. I have received it, my
My
lord.
lord.
I am sharing it,
My
my
lord,
lord.
what your lordship pointed out,
No,
that
no,
will
we
be
are
seven.
asking you something,
My lord.
some facts on the ground.
My lord, in that case, my lord, if eviction is carried out,
Hmm.
I can collect information now, my lord,
Hmm.
immediately.
Then?
I can collect information, and in that case also, my lord, if eviction is carried out, in that case also, status quo may be maintained on the shoot.
What status quo?
My lord, what happened, that
What
notice,
status quo?
notice period is not over, as your lordship pointed out. And secondly, my lord, what has been submitted, that speaking order has been passed and served to us. Let them show from record.
That they will, that
My
they
lord.
will show, but
My
we
lord.
are asking you,
My lord,
in view of your prayer for an interim protection,
my lord,
whether eviction is carried out.
my lord, I am giving.
That government council on instruction says it is carried out,
My lord,
right?
that was the urgency, my lord, I mentioned before your lordship. And
That
in
is
that
okay,
case,
but-
your lordship, another thing is this, as your lordship pointed out, three cannot be taken away, taken.
Hmm?
Date three.
That we'll have to
Yes, my lord.
address
Yes,
the court,
yes, yes.
that how
Yeah.
the period of notice is
yes.
to be
My lord.
carried out.
It should be done on 7, but they are carried out on 3. 3 days time is not over.
Heard, Mr. M.A. Sheikh, Learned Counsel for the petitioner, Mr. R. Borpuzari appearing for.
My lord, I am appearing, my lord, for respondent number, my lord, 1.
2, 3
and 4, I am available.
1. Mr. D. Nath for
2, 3 and 4.
2, 3 and 4. The petitioners, 28 in numbers, claim to be residents of the area, the particulars of which are specified in the schedules.
Schedule A, my lord, to Schedule A2, my lord.
Schedule A to Schedule A2,
My lord.
which are enclosed to the writ petition. So, the grievance of the petitioners are that by way of eviction notice dated 3/1/2026, issued individually to the petitioners, the respondent authorities have sought to undertake the process for eviction of the petitioners. As this land stated to be under the occupation of the writ petitioners are said to be requisition land. Stop. The Learned Counsel for the petitioner submits that this notice was served on the petitioners, giving 3 days time to reply. And as such, in view of the urgency, in view of the short period for replying to the notice, the petitioners have expressed strong apprehension that the eviction process will be carried out today. So, the Learned Counsel for the petitioner has also referred to the order dated 17/11/2025, passed in WPC 6454 of 2025, which was filed by the petitioner.
But with due respect to my friend, my lord, eviction is not carried out. They are in preparation. They are in preparation. my lord.
I have
Wrong
read-
information given by the deputy commissioner, whom I learned friend.
Record it, my
Yes.
his submission and my written instruction.
WPC 6454 of 2025. And which was filed by some of the petitioners. And coordinate bench of this court, while disposing of the petitions, Directed is under para 8, extract page number 34. It is the claim of the petitioner, it is the contention of the petitioner that pursuant to the order dated so and so, passed in WPC so and so, petitioner is represented before the authorities, which were duly received. However, to the best of the information of the petitioners, these representations were not disposed of. Stopped. It is therefore submitted that when there is a specific direction by this court to pass effective orders on the representations, until such disposal, no coercive action is to be taken against the petitioner in terms of the notices or orders, the issuance of the impugned eviction notices without due compliance of the directions of the court in WPC number so and so, by the order dated so and so, is arbitrary and opposed to public policy, and therefore the impugned eviction notices be interfered with, set aside and quashed, and during the currency of the proceedings, the operation of the said notices be suitably stayed. Mr. R. Borpuzari, learned counsel representing respondent 1 on instructions, submits that the direction issued by the court by the order dated so and so in WPC so and so was duly carried out, and the petitioners therein were duly heard, and speaking orders were passed, and copies thereof were also served on the petitioners. Stop. He further submits that since the period of notice in the present notices dated 3/1/2026 was issued, in the present notices was for a period of 3 days, and the notices having been issued on 3/1/26, the period of 3 days expired on 5/1/2026, and therefore the respondent authorities have already proceeded to evict, undertaken the eviction process in the said land as per instructions received from the DC.
Well, DC Dhubri, Lordship, I have placed the instructions, my lord.
DC Dhubri, written instructions.
Yes, my lord. Lordship, maybe please to peruse it, my lord, and keep it as a part of the record, my lord, for the time being.
The learned standing counsel has also placed before the court copy of the written instruction received from the district magistrate Dhubri dated 6/1/2026. No, this is with, all right.
And my lord.
It is in this, as per the said instructions. Counsel for the parties have been heard. It would be Mr. D. Nath, learned senior government advocate representing respondents 2 and 3.
2, 3 and 4.
2, 3 and 4.
I have similar submission.
Also make similar submission on instructions, and submits that the eviction process has already been undertaken.
No, it is completed, my lord. It is already complete.
Undertaken and completed.
Complete. That is what my written instructions.
Having heard counsel for the parties, then upon perusal into written instructions, it is seen that the district magistrate Dhubri, by order dated 6/1/2026, has clearly informed, instructed the learned standing counsel, revenue and disaster management, that the eviction process started at 7:30 AM in the Charua Bakra JB, Chirakuta area, and was duly completed by 1:40 PM. The instructions also reflect that in terms of the directions contained in directions dated 17/12/2025, passed in WPC so and so and other connected petition. The hearings with regard to those petitioners have already been carried out, and speaking orders and payment details are also enclosed to the said instructions, which however have not yet been placed before the court. The primary objection of the writ petitioners, the primary challenge of the writ petitioners to the impugned notices is that the same were issued without complying with the directions contained in the order dated so and so, passed in WPC so and so. It, however, has been contradicted by the respondent counsel on written instructions to submit that these averments, these contentions are incorrect, as the representations were taken up, hearings conducted, and the speaking orders were already issued. Stop. Under such circumstances, it would be apposite to direct the respondent authorities to place before the court the orders passed, speaking orders passed by the respondent authorities in respect of the writ. You are also writ petitioners in the earlier case.
Yes.
In respect of the writ petitioners in the present proceedings, pursuant to the directions contained in the order dated so and so, passed in WPC so and so. So, since there is a dispute as on date as to whether the eviction has been carried out, as the learned counsel for the petitioner on instruction submits that the eviction process has not yet been carried out, and the steps are being taken to undertake the eviction process, and which is contradicted on the basis of instructions by the respondent authorities that eviction process was duly carried out on 6/1/2026 at 7:30 AM and was completed by 1:40 PM. This court considers it appropriate to what steps will you take now after that?
No, it is basically, my lord, for establishment of power plant. These are acquisition matters, my lord. They are not the landowners, in fact, even.
Lord, we are pattada. We are not landowner. How the land will be acquired?
The eviction, it is directed by the court that the eviction of the writ petitioners, which has been carried out, stated to have been carried out by the respondents, will be made subject to the outcome of the writ petition.
Yes.
Writ petition, stop. If the eviction is carried out as stated by the respondent authorities, the petitioners will be, the respondents will ensure that the writ petitioners are granted all the facilities and the privileges which are prescribed under, what is that, land
My lord,
policy?
yes, my lord, this is Assam Land Requisition and Acquisition Act 1964.
No, there is a land policy.
Assam Land Policy
2019.
2019.
Regarding what facilities you are required to give for persons who are evicted.
No, my lord, here, lordship, they are evicted because now once they are evicted, they are already given a compensation. That is what my instructions say. Kindly see my instruction, my lord, for a moment, my lord. Instruction. Sanction orders, indemnity bond. They were given compensation.
That is not accepted by us.
No, it is up to them. If they,
Your
if
Honor,
they have
your
a
lordship,
No,
eviction.
If compensation.
Contradiction, my lord.
No, what are these?
Contradiction is this, my
What are
lord.
these lands used for?
My lord.
These are farmland, agriculture,
No, house, dwelling land. my lord.
dwelling land.
Yes, my humble submission before your lordship. I am contradicting that eviction is not carried out. Now what happened, my lord? Land after acquisition will be handed over to APDCL. So, my lord, that cannot be done till they file the affidavit.
No, that will say it.
Yes, my lord.
The, when can you give us, when can you file your affidavit?
Well, immediately on reopening, my lord.
Right.
Immediately on reopening. My lord, lordship may be pleased to fix this on, my lord, on 21st, my lord. Before 21st, we will file the affidavit.
Matter be listed on 21st of
Yeah,
January.
yes.
And till the next date fixed, the
Because my humble submission, my lord, with all respect, this is not an eviction of encroachers. This is an eviction under the statute. At the most, they will
My
be
lord,
indicted
my lord,
only for.
in that case, my lord, in that case, my lord, my humble submission.
allow us to dictate the order.
My lord, my lord.
Allow us to dictate the
My,
order. Hmm. The respondent authorities will not take any further steps in respect of this land till the next date fixed. That's all. You're not clarifying what you are supposed to do, what you're not supposed to do.
my lord, it is already there. My lord, lordship will kindly see, my lord, page 52. Page 52 of the writ petition. My lord, that is or of every notice, and for that matter, lordship may be pleased to see, my lord, page 37. This is the first notice. Kindly see, my lord. They cannot resist, my lord, acquisition. It will be resistance to acquisition.
No, my lord, here, may I submit, my lord? If your lordship looked into the earlier orders.
My lord, page 37.
My lord,
It is.
after giving notice.
I'm making a reference. Please let me
Which
submit.
paragraph?
Please
Which
let me
paragraph?
submit, sir. I'm making my reference. Please let me submit. You will get your turn, sir.
Yes, yes, go
Yes.
to court.
Which paragraph?
My lord, second paragraph. Second paragraph. Whereas sanction has been accorded by this office order number so and so 30/12/25. It all started
No,
much
that's all
ahead.
right. Don't take any further action till 19th. That's all we are saying. We are not, if you, on the basis of the fact that eviction has been already carried out, we are not staying here. But we
Yes.
won't take further action with regard to this land
Okay.
till 19th.
Yes, yes.